Hi everyone, welcome back. In the last lecture, I suggested that new property rights are often the result of disputes over how particular objects are going to be used. When someone tries to use an object in a particular way and somebody else objects to that person's use of the object in that way, and they can't reach some sort of informal agreement, then typically they go to a court and they ask the court to resolve the dispute for them. The court does so by either saying that the person has the right to use that object in the way that he or she claims, or alternatively, that the other person, the objector, has the right to control that use of the object and can stop the first person from using the object in that way. When a court makes a decision like this, as we've suggested, it pulls an empty arrow out of the quiver, attaches a label to the arrow, and hands the arrow to the winner of the dispute. In these next few lectures, I'd like to elaborate on some of these points and develop them a bit further in the context of an extended example about a particular kind of dispute over the use of someone's house. So I'll begin by telling a short story about two neighbors whom I'll call Hamilton and Jefferson, great names out of American history, and names that I've chosen so the two parties will have something to dispute over. Let's assume that Hamilton and Jefferson each lives in a small house in a small town, and that their houses are next to one another, and that there aren't any neighbors near enough to be bothered by anything that might happen between Hamilton's house and Jefferson's house. When we raise the curtain on the story, we'll first have a look at Tom Jefferson's house. There it is. It's a small house, and as you'll notice, it has a small room on the right-hand side, an alcove as we call it, and Tom uses that room as a playroom for his daughter, whom we'll call Rachel. As we open the curtain on the story, you see the number 1,000 under Jefferson's home, and that number is meant, hypothetically, to represent the value of all of the property rights that Jefferson owns to that building to Jefferson himself. So, for example, the $1,000 measures the value to Jefferson of the entire quiver of property rights that Jefferson actually owns in his house. To say that he values this quiver of rights at $1,000 means that if somebody were to offer him $1,001 for all of his property rights, for the entire quiver of rights that he owns relative to that particular house, then Jefferson would accept the offer because $1,000 is more, $1,001 is more than $1,000. Alternatively, if somebody were to offer Jefferson only $999 for his quiver, he would refuse the offer because the quiver is worth more to him than the offer that he has from this other individual. Okay. Sitting next to Jefferson's house, let's assume, is Hamilton's house. Okay. It's a federal house, perhaps quite appropriately for Alex, and you'll notice the number 1,200 under Hamilton's name. That's meant to signify exactly the same sort of thing as the number under Jefferson's name signified. That is, Hamilton owns a quiver of property rights which are attached to his house, and the value to him of the entirety of the quiver of property rights that he owns to his own house is $1,200. That means if somebody were to offer him $1,201 for his quiver, he would sell it. But if somebody were to offer him $1,199 for the quiver, then he wouldn't sell it. Now let's suppose a change in the situation occurs, and it occurs because Jefferson has been given a brand new business opportunity. Suppose that in the town where Hamilton and Jefferson live, there's a factory that makes sirens. And the siren factory comes to Jefferson and offers him a business deal. Tom, they say, every day at 5 p.m., we'll bring a truck by your house, and the truck will contain all of the sirens that we've produced at the factory during the day. We typically produce about 200 or 250 sirens in a day. What we'd like you to do is to take the equipment that we're going to give you and do quality testing on the sirens that we've made. We'll ask you to test each siren to see that it works, And if the siren works, you simply mark it with a tag that says that it works and put it in the bin that holds the sirens that work. And for the few sirens that don't work, you put a different tag on them and put them on the defective box, and we'll take those back the next morning with the sirens that have been tested to work well, and we'll take care of the rest. How does he test the sirens? Well, the equipment that he's been given is very simple. It's simply a battery with 2 wires. He connects the 2 wires to each siren, and then he sees whether the siren makes a noise. If the siren works, it goes whoop, and if the siren doesn't work, it doesn't make a noise. So, Tom estimates it will take him about 2 to 3 hours in the evening, from 5 to 8, to test the 200 or 250 sirens that are going to be given to him every day by the siren manufacturer. The siren manufacturer offers Tom the following deal. If Tom will test those sirens every day from 5 to 8 in the evening in the way that I've just described, then the siren testing company will provide Tom with all of the equipment. It will provide him with compensation for his labor. It will provide him with full compensation for any unpleasantness that he experiences from testing the sirens. And on top of everything, the company will pay Tom $500 in pure profit. And so Tom thinks to himself, this is a wonderful opportunity. He can take Rachel's alcove on the side of the house and turn it into a siren testing laboratory. He'll set up the equipment that the siren testing company brings him, and every day from 5 to 8 in the evening, he'll connect his battery-powered tester to the sirens and see which sirens go whoop and which sirens don't. And for having done this, he'll realize a pure profit of $500. So, as you can see in the slide, Jefferson's quiver of property rights is worth $1,000 if it does not include the arrow that allows him to test sirens in Rachel's alcove. On the other hand, if Tom can get the property right to test sirens in Rachel's alcove, then his quiver of property rights will be worth $500 more than it had been before, because the value to Tom of the property right that allows him to test those sirens in Rachel's alcove is $500. But of course, when Tom tests those sirens from 5 to 8 in the evening, he makes a great deal of noise. And let's say that the noise wafts next door to Hamilton's house, and Hamilton and his family find their dinner hour from 5 to 8 every evening interrupted by hundreds of whoop, whoop, whoop noises emanating from Jefferson's house. And of course, this makes it much more difficult, much less pleasant to find quiet enjoyment in Hamilton's house. And let's suppose that Hamilton values the loss of quiet enjoyment that he experiences whenever Jefferson tests those sirens at $200. And that means the following. As we saw, the value to Hamilton of his entire quiver of property rights, not including a property right having to do with the testing of sirens in Rachel's alcove, was $1,200. Those were the property rights that Hamilton had before Jefferson asserted the right to test the sirens. But if the sirens are run and are tested, and Hamilton does not have the right to stop Jefferson from doing so, his house will simply be less pleasant for him and his family to live in, and the value of those very same property rights, the ones that he had before the sirens were tested and were then worth $1,200, the value of that quiver of property rights will be reduced, in Hamilton's eyes, to $1,200. In a word, testing of the sirens is worth $500 to Jefferson, but if he does test the sirens, he'll impose a $200 cost on Hamilton in the form of denying Hamilton the quiet enjoyment of his home between 5 and 8 on weekday evenings. So, we have a dispute. Can Tom and Alex work it out? Well, maybe they can. They're neighbors after all. It's easy for them to get in touch with one another. They know one another well, and so they begin to think about working it out. And so Alex, who's the aggrieved party, it looks like, walks across the way and knocks on Tom's door and says, "Tom, about those sirens, perhaps we can come to a deal. I'd really be grateful if you'd stop testing those sirens, because in fact it really does disturb our dinner hour, and things have always been so quiet, we've come to enjoy it greatly. So would you please stop testing the sirens?" And Tom says, "Well, Alex, I'm very sorry about the disturbance to your dinner hour, but I'm just trying to make a living, and I have an opportunity to use my house. Rachel's alcove is, after all, in my house, to use my house to earn $500 in undertaking what would otherwise be a perfectly legal activity." So Alex says, now perhaps becoming a little annoyed, Alex says, "Tom, I was here first. You've disturbed the situation that was here before. You've disturbed the status quo. I think I have a right to expect that the status quo will continue, and therefore I think that you cannot test those sirens without my permission, and therefore I ask you to stop." And Tom, now becoming somewhat irritated himself, says, "Alex, are you presuming to tell me what I could do with my own house? It is my own house. There's no law against testing sirens." Tom happens to know that their town has no zoning ordinances, and so there's no reason for you to tell me that I can't use my house in order to test sirens in this way, and I won't let you stand in the way of my providing for my family. Well, it's possible that if the argument goes on for long enough, either Tom or Alex will give in to the other one. Alex might say, "Okay, Tom, you can test your damn sirens, and we'll just suffer the loss." Or Tom might say, "Okay, Alex, I'll put the sirens away and swallow the loss of this profit-making opportunity." But if they do come to such a deal, note that they will have informally defined a property right between them. If Alex forbears from complaining, if he tells Tom to just go ahead and Alex will suffer, then Alex has effectively granted Tom a property right to test the sirens in Rachel's alcove. But if Tom, to keep the peace, agrees not to test the sirens, then he will have implicitly and informally have given Alex a property right in Rachel's alcove, in Tom's house, and Alex will use that property right to keep Tom from testing the sirens. But this is America, and people are not likely to come to an easy resolution of disputes like this, and we're likely to see Tom and Alex next when they go to court. What is it that they're arguing about when they go to court? Well, indeed, we've already seen the answer. They're arguing over the ownership of a particular arrow that's associated with the object of Tom's house, and in particular the part of Tom's house we're calling Rachel's alcove. They're arguing about which of the two of them owns that arrow. If Tom owns the arrow, then he will be able to test the sirens in his own house without compensating Alex for the costs that Tom's testing of the sirens imposes upon Alex. But if Alex wins the case, then he gets the property right to test sirens in Rachel's alcove, and he will use that property right negatively. He won't enter Tom's house to test the sirens himself, but he will control the use of Rachel's alcove by not allowing Tom to use Rachel's alcove to test sirens. And as we've seen, if they can't agree informally, then they will go to court. And again, the dispute will be resolved by a judge, and we can imagine that in resolving the dispute, by telling either Tom that he can continue to test the sirens without winning Alex's consent or compensating him, or if she tells Alex that he has the property right and can prevent Tom from testing those sirens without Alex's permission, we imagine that in deciding the case, the judge goes back into her chambers, takes one of those naked arrows, wraps a tag on it that says the bearer of this arrow has the right to test sirens in Rachel's alcove in the evenings from 5 to 8 p.m. So it looks like there's a lot at stake in this particular dispute. And so let's assume that Tom and Alex have both done their best to secure the best legal talent possible. So Tom and his attorneys and Alex and his attorneys meet one another next as they enter the courtroom to argue the case of Hamilton versus Jefferson, where Hamilton is arguing to the judge that she ought to throw the weight of the law behind his claim to be able to stop Tom from testing those sirens. In the United States, trials are public, and very frequently in a public courtroom, you can see the public. They sit on benches in the gallery and they watch the cases. Years ago, when I was a law student, I was sent to watch a series of criminal dispositions at the local Court of Common Pleas in Philadelphia, and I sat there every afternoon for a full week in the midst of a group of elderly people from a northern suburb of Philadelphia who came down to the courtroom every afternoon to watch, as one of them put it to me, the human drama, which was much better than what you could see on the soap operas at home and television. As I discovered over the course of the week, some of those elderly people were quite knowledgeable. They knew the answers to the legal questions that were being litigated. Certainly they knew them better than I did, because they'd been sitting and watching for many years, and they had a pretty good sense of what kinds of cases were litigated, what the precedents were that helped the judges to decide those cases, and what the likely outcomes of the cases would be. So let's imagine that there's an elderly fellow sitting in the back of the courtroom at the moment that Tom and Alex enter the courtroom to litigate their dispute, each with their dream team of lawyers. And let's call this elderly gentleman Ron. And let's assume that Ron, sitting in the back of the courtroom, whispers a disturbing sentence as Alex and Tom and their attorneys pass by. Boys, he says, it doesn't matter who wins this case. Alex turns to look at Ron. Tom turns to look at Ron. The attorneys turn to look at Ron, and they ask him to repeat what he said. And Ron said, it doesn't matter who wins the case. Well, at this, the attorneys shuffle their clients hurriedly away from Ron. They don't want their clients to hear what Ron is saying, because if Ron is right, and it doesn't matter who wins the case, then nobody needs the lawyers, do they? It doesn't really matter which side wins the case. And so, the question before us is, does it matter who wins the case? We'll find that out next.